An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. American Legion versus American Humanist Association, 2019. So far, we have studied two types of Establishment Clause cases. Engel versus Vitale focused on the constitutionality of prayer in public schools. Town of Greece versus Galloway considered whether government meetings can begin with prayers. This video will focus on a third type of Establishment Clause case. Are religious symbols on government property constitutional? The Supreme Court's most recent decision in this area was American Legion versus American Humanist Association, 2019. But to fully understand American Legion, you must jump back to a pair of cases from 2005. McCreary County versus ACLU of Kentucky, and Van Orden versus Perry. Both cases involved public displays of the Ten Commandments, one in Kentucky and the other in Texas. Both cases were decided on the same day in 2005 by a 5-4 vote. The Kentucky display was declared unconstitutional, while the Texas display was upheld. How did this split happen? Let's start with the Kentucky case. Over the course of a year, officials in McCreary County, Kentucky erected 3 separate displays of the Ten Commandments in their courthouse. The first display consisted of a large gold-framed copy of the Ten Commandments. The American Civil Liberties Union of Kentucky, ACLU, challenged the constitutionality of the first display. In response, the county erected a second iteration of the display. The second display added smaller-sized patriotic and legal documents around the framed Ten Commandments that highlighted religious references. The district court found the second display was unconstitutional because it, quote, lacked any secular purpose, and the county's object was instead to advance religion. The phrase secular, as opposed to sectarian, refers to a non-religious purpose. After this ruling, the county erected a third display. The third version included an extended text of the Ten Commandments surrounded by equal-sized copies of such documents as the Bill of Rights and the lyrics of the Star-Spangled Banner. The Supreme Court ruled that McCreary County violated the Establishment Clause by a 5-4 vote. Justice Souter's majority opinion found that the purpose behind the displays was to advance religion. Here, the court followed the so-called Lemon test. In Lemon v. Kurtzman, 1971, the Supreme Court created a 3-part test to determine whether a law complies with the Establishment Clause. First, the law must have a legislative purpose that is secular or non-religious. Second, the law cannot have the effect of advancing or restricting religion. Third, the law must not create an, quote, excessive entanglement between religion and the government. Justice Souter concluded that McCreary County acted with a religious purpose and violated the first prong of the Lemon test. The court did not consider the effect or entanglement prongs. On the same day that McCreary County was decided, the Supreme Court also decided Van Orden versus Perry. On the grounds of the Texas State Capitol was a 6-foot-high stone monument inscribed with the Ten Commandments and other religious symbols. the Fraternal Order of Eagles gifted it to the state in 1961. By a 5-4 vote, the court held that the Texas, quote, display of this monument with both the legacy and secular significance does not violate the Establishment Clause. Justice Breyer joined the majority opinions in both McCreary County and Van Orden. Breyer's approach seemed to turn on another factor, the age of the monuments. The display in McCreary County was new. But the display in Texas, Breyer observed, had, quote, stood apparently uncontested for nearly 2 generations. For this reason, he wrote, keeping the, quote, display is unlikely to prove divisive. Justice Breyer feared that a court-ordered removal of this long-standing monument would lead to similar challenges across the nation. Such litigation, he feared, would then generate, quote, the very kind of religiously based divisiveness that the Establishment Clause seeks to avoid. 14 years later, the Supreme Court would decide American Legion versus American Humanist Association. Justice Alito described the facts of the case during the hand-down of the majority opinion.
In late 1918, residents of Prince George's County, Maryland, formed a committee for the purpose of erecting a memorial for the county's fallen soldiers. In World War I,
the county decided to build a 32-foot tall Latin cross. It was erected on a large pedestal in the middle of a public highway. Alito observed that
the Bladensburg Peace Cross has stood since 1925 as a tribute to 49 area soldiers who gave their lives in the First World War.
The American Humanist Association challenged the cross as a violation of the Establishment Clause. The plaintiffs, Alito explained,
asked that the cross be removed or demolished, or at least that the arms be amputated.
The Supreme Court upheld the display by a 7-2 vote, but the majority opinion was fragmented. Justice Alito wrote the controlling opinion. Concurring opinions were written by Justices Breyer, Kavanaugh, Kagan, Thomas, and Gorsuch. Justice Ginsburg dissented and was joined by Justice Sotomayor. Justice Alito joked that
my colleagues and I have been quite prolific in our writing about this memorial.
The court divided over 4 primary issues. First, all of the justices seemed to agree that this case could be resolved, at least in part, based on, quote, history and tradition. Town of Greece versus Galloway, 2014, held that the Establishment Clause must be interpreted, quote, by reference to historical practices and understandings. But in American Legion, the justices disagreed about what exact role history and tradition should play. On this point, Justice Alito wrote a plurality opinion, which was joined by Chief Justice Roberts and Justice Kavanaugh. Alito suggested that there should be a, quote, presumption of constitutionality for long-standing monuments, symbols, and practices. And this troika concluded, quote, categories of monuments, symbols, and practices are likely constitutional if they are supported by a, quote, long-standing tradition that recognizes the important role that religion plays in the lives of many Americans. Justices Gorsuch and Thomas rejected this presumption of constitutionality based on tradition. Quote, The Constitution's meaning is fixed, Gorsuch wrote, and a practice consistent with our nation's traditions is just as permissible, whether undertaken today or 94 years ago. In other words, the Peace Cross is constitutional regardless of whether it is supported by history and tradition. Study guide. Does the court hold that only history and practice should be considered in Establishment Clause cases? What other factors can be considered? Justice Breyer, who joined Justice Alito's opinion in part, stated that the court did not adopt a history and tradition test. Rather, in Breyer's view, Justice Alito's opinion considered history and tradition for guidance, along with other factors, including the, quote, particular historical context of the Peace Cross and its long-held place in the community. Likewise, Justice Kagan did not, quote, sign on to any broader statements about history's role in Establishment Clause analysis. She would instead look to history and tradition on a, quote, case-by-case basis. Second, the court split about the meaning of the Bladensburg Peace Cross in light of history and tradition. All of the justices agreed that a cross is an inherently Christian symbol. Justice Ginsburg observed that, quote,
the Latin cross is the foremost symbol of the Christian faith, embodying the central theological claim of Christianity, that the Son of God died on the cross, that he rose from the dead, and that his death and resurrection offer the possibility of eternal life.
But that religious symbolism did not end the case. Neil Katyal, the lawyer from Maryland, argued that
the easiest way to resolve this case is to say in the wake of World War I, crosses like this one had an independent secular meaning.
The court would adopt Katyal's reasoning. During the opinion hand-down, Justice Alito explained that
the symbol of a plain white Latin cross took on new meaning in the wake of World War I. American military cemeteries in Europe, those from World War I and also from World War II, what will strike you is this image of row after row of plain white crosses.
And following that tradition, Alito explained, local communities in the United States recognized the cross not just as a purely religious symbol, but also as a symbol to commemorate fallen soldiers. In dissent, Justice Ginsburg disagreed. She said that the cross could not be viewed as a secular, non-religious symbol.
In World War I and thereafter, the cross was never perceived as an appropriate headstone or memorial for soldiers who did not adhere to Christianity. Even in Flanders Field, Stars of David marked the graves of 8 American soldiers of Jewish faith.
Justice Alito recognized that, quote,
more than 3,500 Jewish soldiers gave their lives for this country in the First World War, and their sacrifice must not be forgotten.
But in his view, that particular historical fact did not affect the constitutionality of the Bladensburg Peace Cross. Alito said that
there is no evidence either that the name of any Jewish soldier from the area was excluded from the list on the memorial, or that the name of any Jewish soldier was placed on the memorial against the wishes of his family.
In short, the court held that the, quote, symbol took on an added secular meaning when used in World War I memorials. Moreover, quote, with the passage of time, the Peace Cross had acquired historical importance. Today, the monument, quote,
reminds the people of Bladensburg of the deeds of their predecessors both those who served in the war and those who erected the monument.
Third, the majority ruled that demolishing the Peace Cross would send a message of hostility to people of faith. Justice Breyer had expressed this concern 14 years earlier in Van Orden versus Perry. He worried that tearing down the Ten Commandments monument in Texas would demonstrate animosity toward Christians. During the oral argument in American Legion, Justice Breyer expressed this same concern.
We're not going to have people trying to tear down historical monuments, even here. Okay?
Justice Alito followed up on this theme.
What message does that send? When people see that on TV, they see crosses all over the country being knocked down.
During the opinion hand-down, Alito explained,
For many people, destroying or defacing the cross that has stood undisturbed for nearly a century would not be neutral, and it would not further the ideals of respect and tolerance embodied in the First Amendment.
Justice Ginsburg countered, the demolition was not the only remedy. She wrote, quote, in some instances, the violation may be cured by relocating the monument to private land or by transferring ownership of the land and monument to a private party. However, it is not clear if either option was available for the Bladensburg Peace Cross. In the end, the court concluded that, quote, the cross does not offend the Constitution. Justice Ginsburg vigorously disagreed.
The court erodes that neutrality principle, diminishing precedent, serving to preserve it. The state places Christianity above other faiths and conveys a message of exclusion to non-Christians, telling them they are outsiders, not full members of the political community.
This dissent will be the last one that Justice Ginsburg read from the bench. In March 2020, due to the COVID-19 pandemic, the Supreme Court canceled all in-person sessions. Justice Ginsburg passed away on September 18, 2020. 1 month later, Ginsburg would be replaced by Justice Amy Coney Barrett. Fourth, and finally, the court divided about the relevance of the Lemon Test. During oral argument, Justice Kavanaugh observed that the Supreme Court has not followed the Lemon Test in leading Establishment Clause cases.
Our cases have upheld religious displays and religious words in cases like Marsh, cases like Van Orden, the Ten Commandments, cases like Town of Greece, legislative prayer before a meeting. How can it be useful when we haven't used it in the most important cases that are on point here?
Justice Gorsuch made the point more directly to Michael Carvin, the lawyer for the American Legion.
You tell us we should abandon Lemon's endorsement test because it's become a dog's breakfast. Nobody knows how to apply it. Circuit courts are confused, you tell us.
Ultimately, there were not 5 votes to expressly overrule Lemon versus Kurtzman. Still, Justice Alito's plurality opinion criticized the Lemon Test and declined to follow it. However, Justice Kagan, who joined the majority opinion, endorsed the Lemon Test. She contended that the Lemon Test's focus on purposes and effects is crucial in evaluating government action. Others disagreed. Justice Kavanaugh wrote in his concurrence that, quote, the court's decision over the span of several decades demonstrated that the Lemon Test is not good law. Justice Gorsuch seemed to agree. He wrote that, quote, Lemon is now shelved. Justice Thomas, quote, would have taken the logical next step and overruled the Lemon Test in all contexts. After American Legion, it was unclear whether the Lemon Test should still be followed. 3 years later, the Supreme Court would resolve this issue in Kennedy versus Bremerton School District 2022. In this case, Joseph Kennedy, a high school football coach, would quietly pray after games at the 50-yard line. Some players from both teams would pray with him. The school district determined that Kennedy's prayers were a possible violation of the Establishment Clause. The coach claimed that his right to pray after the games was protected by the free speech and free exercise clauses. The lower courts, however, held that the school could restrict the coach's speech and exercise to avoid an Establishment Clause violation. On appeal, the Supreme Court ruled for Kennedy. Justice Gorsuch wrote the majority opinion, which was joined by Chief Justice Roberts and Justices Thomas, Alito, Kavanaugh, and Barrett. The court held that the free speech and free exercise clauses protected Kennedy's prayers. The court also recognized that the prayers did not violate the Establishment Clause. To reach that result, the court addressed the status of the Lemon Test. Justice Gorsuch stated that, quote, "This court long ago abandoned Lemon in American Legion and the Town of Greece v. Galloway, 2014. Study guide. Did American Legion and Town of Greece, quote, abandon the Lemon Test? Further, Justice Gorsuch observed that American Legion, quote, instructed the lower courts to use a different test, quote, in place of Lemon. Rather, quote, the Establishment Clause must be interpreted by reference to historical practices and understandings. Gorsuch stressed that the courts must, quote, focus on original meaning and history. In this case, the school district and the lower court, quote, erred by failing to heed this guidance. Justice Sotomayor wrote the dissent in Kennedy, which was joined by Justices Breyer and Kagan. Sotomayor observed that American Legion only, quote, criticized the Lemon Test, but did not categorically reject the precedent. Yet, now the court has, quote, overruled Lemon. Moreover, the majority, quote, called into question decades of subsequent precedents that the majority deemed offshoots of Lemon. Study guide. Did the court actually overrule the Lemon Test? Is there a difference between overruling a precedent and treating it as, quote, abandoned? The Supreme Court has instructed the lower courts to interpret the Establishment Clause based on history and tradition. The Lemon Test and its offshoots are not to be followed.